Top story coming out of New York this morning. How Rex Heuermann's defense team is responding to a bombshell ruling coming this week that the defendant in the Gilgo Beach murders case will now face one trial for all 7 homicide allegations. A New York State Supreme Court judge issued the ruling on Tuesday after his defense attorney moved to try the cases separately. Now, Heuermann is accused of killing 7 women between the years 1993 and 2010. He has pleaded not guilty in the case. Now, this ruling comes just 1 week after prosecutors announced that they're ready to go to trial, but no trial date has been set. Now, Rex Heuermann's attorney, Michael J. Brown, is here on the show this morning to talk about that ruling. Let's bring him in now. Michael, good morning to you. First, we want to get your reaction, if we can, please, to the ruling.
Well, Julie, there were several rulings that came out the other day. One was the severance issue, which you're referring to, and there was also the motion to preclude the DNA because of the violation of New York State public health law. We're obviously disappointed. My position is always don't waste anybody's time. I respect the court's time. I respect my adversary's time. So I don't just file motions for the sake of making motions. We make motions because we think we have a strong argument. And that's the case in this instance. We thought we had a very good argument on both grounds. We obviously lost. The court ultimately makes that decision, and we're stuck with that. The issue is well preserved for appellate purposes in the event we don't prevail at trial. So we move forward. We go forward. We continue to prepare. We continue to fight for our client, and with an eye towards trying the case.
Exactly. You know, for anybody who may not be familiar with your work or maybe has never tuned into the show, if this is the first day, I always say Michael J. Brown's going to have a backup plan for his backup plans. You are an incredibly seasoned trial attorney, and so I can't help but think you knew this would be a possibility, right? Have you been planning for this in the event that it doesn't go the way you had hoped?
Yeah, Julie, these motions, again, you have the DNA and you have the severance issue. The court had to make that decision. It's a high publicity case, a lot of notoriety, a lot of eyes watching, and the court denied our motion. So yeah, we go forward. We're going to try one case as opposed to 2, 3, or 4 cases. So yeah, did we expect a decision in our favor? I'm not going to say we expected it. We had hoped for it, and we thought we were correct on the law. But again, so we go forward on one case and do our best with the one trial.
Michael, tell me, explain to us why it would have been advantageous for you and your client to go one by one on each of these allegations.
Well, and again, Julie, remember, so we conceded the 3 out of the 4 original Gilgo 4. Those should be tried together. So our original application was 3 of the victims should be tried together, and the other 4 should be separated and should be individual trials. When you have, assuming it was granted, for instance, which I think is what you're asking, well, if it's 3 together, we can focus on those 3, and we can focus on those 3 victims and the evidence on those 3 victims. And then when you go to the next trial, you can focus on that particular case and so forth. So it definitely makes it easier for the defense to be able to narrow down the focus of the case. But keep in mind, there are differences, and that's part of our motion. There are significant differences in some of the victims and some of the particularities of those cases. So that may have come out anyway on cross-examination because it kind of shows that he is not the culprit. He is not the individual who committed these crimes. But the point of the motion is that should be our decision to make, not the prosecutors. And initially we wanted it severed. And if we wanted to introduce certain evidence that contradicts their theory, that would be our option, not theirs.
Understood. Michael, let's go back to something you touched on, the other big ruling about the advanced DNA being allowed in at trial. What does this mean for you and your client?
Well, as you know, we were fighting this new whole genome sequencing and, more importantly, the IBD gem and those results, which are off the charts, completely on the other polar end of the mitochondrial results. And we were trying to preclude that. We lost. We were not successful. Now, a couple of things. I think that the Fry hearing, which is our initial threshold hearing that we conducted, I think we prevailed in that hearing. I think it was clear from the evidence adduced both on the people's case and on our case that this is not general acceptance in the scientific community. The judge didn't agree with us. It is well preserved for appellate issues in the event we're not successful at trial. Having said that, Julie, remember, it comes into evidence subject to the foundational requirements, but that does not mean we can't cross-examine. And I spent a good 6 months on preparing the Fry hearing, so I have a lot of ammunition to cross-examine these very same witnesses during the course of the trial. And I think actually it would be even more effective in front of a jury, because the things like the bias, the things like the money, the things like the interest and trying to further your own career, all these things are important, and they'll be more important in front of a jury. So yes, it will come in subject to those foundational requirements, but we still have an ability and an opportunity to cross-examine those witnesses before the fact finders, namely the 12 jurors.
Michael, appreciate it. Tell us, are we close to a trial date being set yet, or is that still too far off in the future?
I think we're off for a bit. Right now, the judge put it over till January for us to file any additional motions, and there's a lot of search warrants, and we're certainly going to explore any of, improprieties and illegalities in those search warrants. So we'll have those motions in hopefully by that January, I think it's 13th date. And at that point, shortly afterwards, I do expect the judge will set a trial date, maybe with an eye, and this is just my guesstimate, maybe with an eye towards September of 2026.
Okay, so a good ballpark. At least it gives us a little bit of an idea of when it may take place. Michael J. Brown, appreciate you sharing what you're able to share about this case. As you know, it's making headlines all over the place. And for anybody who may have tuned in to see this interview, Michael's on every Thursday morning with us, and we're going to pick his brain coming up next.